Welcome to Property Law 101. I'm Sara Bronin, and I created this series so that you could understand the fundamentals of property and property law. We cover 4 fundamental questions in this series, and today we are talking about the third, using property, and specifically we'll be talking about variances, which are approvals to develop a lot in a manner prohibited by the language or usual application of the zoning law. In giving you that definition, I'm offering you a sneak peek into the 4th restatement of property law, which is on a path to being adopted, I hope soon, by the American Law Institute. Of course, that draft definition is subject to change, but as the primary drafter of the land use volume, I'm hopeful it will be pretty close. All right, so keeping that definition in mind, here's how a variance typically works. As another video in this series says, variances are reviewed and decided by zoning boards of appeals or boards of zoning adjustments. For simplicity, I'll call them zoning boards in this discussion, regardless of what the state might call them. If you're a property owner and if you have plans to build a project and it's within the rules of the zoning ordinance, you don't need to go before a zoning board to get a variance. If you want to, for example, build a house which is taller, however, than the zoning code allows, or start a use, for example, a home occupation not allowed in the code, then you probably do have to go ask the zoning board for permission for the construction or for the use. Usually you have to get approval for the deviation before you can get a building permit. And that's the point at which most people realize that they have to go to a zoning board for a variance. There are 2 types of variances, both suggested in just this last example that I gave. So a use variance allows the property owner to engage in activities on the property that are prohibited by the zoning law. That was the home occupation example. An area variance, on the other hand, allows a property owner to build a structure or make other improvements prohibited by the zoning law. Area variances also encompass proposed changes to lots. Generally, use variances are harder to get than area variances. Some states, for example, require use variance seekers to show an unnecessary hardship before they can get the variance. Other states prohibit use variances altogether. But that's not always the case, as zoning boards and courts sometimes conflate area and use variances, and even in states where use variances are not allowed, still find a way to grant them under the guise that they are area variances. Complications for another time. In variance cases, the presumption is that the property owner is not entitled to the variance. It's incumbent on the property owner to show that he or she has a hardship. If they do not produce credible evidence of a hardship to the zoning board, then they might be denied, or they should be denied, a variance. So the draft 4.3 statement says variances can only be approved upon a showing that special conditions unique to the particular lot and literal enforcement of the law would result in undue hardship. The hardship can't be self-created. The variance cannot conflict with the purpose of the ordinance, and the public and substantial justice must be done. So that's a paraphrase of that definition. But this phrase, hardship that is not self-induced or self-created hardship, is important because courts and local jurisdictions generally block zoning variance applications where the property owner has herself created the hardship. So what happens if someone is dissatisfied with a zoning board decision? Assuming they have standing, they can appeal in state court under procedures that are set forth by state statute, typically the State Administrative Appeals Act. The standard here is usually that the zoning board decision has to not be clearly erroneous, arbitrary, capricious, or an abuse of discretion. The court in those cases can only hear evidence that was actually presented to the zoning board itself. So it's not supposed to be de novo review on the facts. There are a lot of dimensions to variances. There's a full chapter of this in the zoning law treatise that I cover, but I have to leave it there for now. I hope to hear from you through Twitter, through my mailing list, and I will talk to you next time. Thanks so much.